Welcome back, everyone. Today we're doing something a little different. Maybe sounds a bit dry. We're diving deep into the federal rules of civil procedure. Just one rule, actually, Rule 9C.
Yeah.
Now, I know, pleading special matters, specifically conditions precedent, doesn't exactly scream excitement. But trust me on this, buried in this single sentence is some really powerful tactical stuff for lawyers. It's all about how you start a lawsuit, and it creates these completely opposite jobs for the plaintiff and the defendant using just two words, generally, versus particularity. So our mission today, uncover those demands and the strategy hidden inside.
Yeah, it's absolutely key. And not just if you're in federal court. What's interesting, and you see this in the source notes we looked at, is that this federal way of handling conditions precedent, who has to prove what in the first documents, that's pretty much how most state courts do it too. So what we figure out here today, it's useful almost anywhere.
Okay, good. So let's start with the basics then. Before we get into the rules tactics, just what is a condition precedent? If you're, say, looking at a contract dispute, why is how you mention this thing in the paperwork so important?
Right. So a condition precedent is basically an event or maybe something someone has to do that's written into a contract or an insurance policy, maybe even a law. And that event has to happen before the other side is obligated to do their part, before a right kicks in. It's like a prerequisite. Think of it like building a house. Your contract might say the final big payment isn't due until the city gives the okay, the certificate of occupancy. Getting that certificate, that's the condition precedent. If the builder sues you for the final payment, they first have to show, yep, the certificate was issued. Rule 9C is about how they say that in court and, importantly, how you would argue against it if you're the one being sued.
Got it. So the whole lawsuit could hinge on whether this one thing happened. Okay, let's take the plaintiff first. The person suing, usually arguing the condition was met. Rule 9C, the first part, talks about what they need to write down. How much detail do they need?
This is where the rule really cuts the plaintiff some slack. It says, essentially, when you're pleading that conditions precedent happened, it's enough, it suffices to just say generally that everything required was done.
Generally. That sounds really vague, especially if fulfilling these conditions is, like, essential for the whole claim. Why would the court let them get away with such a low bar? Shouldn't they have to prove it up front?
Yeah, it seems counterintuitive at first glance. But the reason is really about efficiency and avoiding problems we used to have. Imagine a huge construction project or a really complex insurance policy. There could be dozens, maybe hundreds of little conditions precedent in the fine print. File this form, use certified mail, notify that department. Tiny stuff. If the plaintiff had to list out and prove every single one of those little things in their very first complaint, you'd have these massive, unwieldy documents, mostly arguing about things the defendant probably doesn't even dispute.
Ah, okay. So the court's kind of saying, look, we'll assume you did the basics unless someone specifically calls you out on it, avoids getting bogged down.
Exactly. The underlying policy is, let's assume things were done right unless told otherwise. The plaintiff just needs that one general statement. It lets the case move forward without getting dismissed over some minor paperwork issue nobody really cares about. It puts the ball squarely in the defendant's court to make an issue of it.
Right, so the plaintiff gets a bit of a pass initially. Just, yep, did all the things. Okay, so now let's flip it. What about the defendant? The one who wants to argue, no way, you didn't meet that condition. What does the rule make them do?
And here's where that contrast really matters. It becomes a potential trap for the defendant, honestly. The second part of Rule 9C is crystal clear. But when denying that a condition precedent has occurred or been performed, a party must do so with particularity.
Okay, particularity.
Yeah.
That sounds like the complete opposite of generally. This is the core of it, right?
Yeah.
What does that actually mean in practice? What does the defendant have to write down?
It's night and day. The defendant can't just file a standard denial, saying something like, defendant denies plaintiff met the conditions precedent. That's not enough. Often that's a critical mistake. Particularity means you have to point fingers. You have to say exactly which condition you're talking about and why you think it wasn't met. You need to reference the specific clause, the specific action, the specific missed deadline.
Okay, let's use your insurance example again. Say the policy says you have to report an accident within 48 hours. If the insurance company thinks you were late, how do they plead that with particularity?
Right. So a bad denial, the one that fails, would just say, denied as to condition 7. A good denial, the one that meets the Rule 9C standard, needs specifics. Something like, defendant denies condition 7, the 48-hour notice requirement was satisfied. The accident occurred Sunday, June 1st, around 9 a.m. Plaintiff's notice wasn't received until Wednesday, June 4th at 11 a.m., which is well outside the required 48-hour time frame. See, that flags the exact issue for the court. Now, everyone knows the fight is about that specific delay. Was it excusable? Was the timing calculated differently? But the defendant has successfully put that specific failure into play.
So it forces the defendant to be precise. They can't just vaguely suggest something was wrong. They have to pinpoint the alleged failure.
Exactly. And that's the elegance of it strategically. Because here's the kicker. If the defendant doesn't deny with particularity, if they just file that lazy general denial, the law treats it as if they admitted the condition was met.
Whoa, okay, that's the power play. So the plaintiff might not even need to show proof they made the deadline because the defendant messed up the paperwork.
That's absolutely right. The way the rule is structured, it actually shifts the burden of proof. If the defendant fails to deny a specific condition with particularity, that condition is essentially off the table. The plaintiff doesn't have to prove it at trial. It's considered admitted. Think about the time, the money, the risk that saves the plaintiff. It's huge.
That really brings it home. Rule 9C sets up this clever imbalance. Plaintiff gets an easy start on conditions, but the defendant has a very high bar to jump over if they want to make it an issue. It's really designed to focus the fight on what's actually disputed.
Precisely. Which brings us to that final, really critical point. This whole structure, it has teeth. There are serious consequences for getting it wrong. So, given that the defendant has to deny with particularity, what happens if they just miss it? What if their lawyer files a standard boilerplate denial for everything, including conditions precedent? What does that mistake cost them?
You're leaving us hanging there, but I think I see where you're going. It sounds like that simple mistake, overlooking one word in the rule, could potentially cost the defendant the entire case before it even really starts.
It absolutely can. It's not just giving the plaintiff a free pass on proving that element. By failing to deny with particularity, the defendant has legally admitted that condition was fulfilled. So the plaintiff can immediately point to that admission and say, see, they agree this condition was met. They might even win summary judgment on that basis. The case could be over because of one poorly worded sentence in the initial response. That's the hidden power and danger of procedural details like Rule 9C.